Good morning. Please be seated. This is the time and date set for oral argument in State of Arizona versus Robert Carrillo. These proceedings are being video and audio recorded as well as live streamed. So we ask you to identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, we've read the briefs. We have conferenced this case. We're familiar with the factual underpinnings. And at this point, we're ready if you are, counsel.
Good morning, Your Honors. May it please the Court, Woody Thompson on behalf of Mr. Carrillo. Also present is Hannah Porter on behalf of Mr. Carrillo. As you're aware, I have two main arguments. I'll take them in order as we brief them. First, the search warrant in this case is a product of interviews with two separate witnesses. And based on those two interviews, the officer crafted a search warrant affidavit designed as an advocacy piece to establish probable cause. But we need to go back and look at the definitions in Arizona state law that provide us the guidance here. Because to establish the probable cause for the crime of sexual exploitation of a minor, there has to be images involving exploitive exhibition or other sexual conduct. There is no mention of any sexual conduct in these images whatsoever. So what we're really looking at here is exploitive exhibition. And so ARS 133551 provides that exploitive exhibition means actual or simulated exhibition of genitals or pubic or rectal areas. And when you look at what was actually provided, the information falls short of that. It doesn't make the threshold of probable cause. And another way of saying that is the officer must reasonably believe that the information he is getting is child pornography. But every time that the officer drilled down with the witnesses, there were discrepancies between the two witnesses, but particularly even with Zayas, the second witness, she continuously said that the children depicted in the images were clothed.
So
Meaning,
counsel, when we talk about clothed, is lingerie clothing? I mean, because she specifically says wearing lingerie.
yes, I certainly would argue it is, because the statute says that it has to be an exhibition of the genitals, the pubic or rectal areas. And when the officer specifically asks about the breast area, in one of the interviews of Zayas, which is that is IR 41, she talks about not being able to see that because there's a bra. And then every time they talk about nudity, she's quick to point out they were clothed, they were wearing lingerie. So I would certainly argue that lingerie is an item of clothing for the purposes of this statute, because what they don't have is that the genital areas were actually exposed, that the lingerie wasn't covering them up.
But the individuals depicted were posed in a sexually suggestive manner at a minimum, correct?
There is evidence in those interviews that she describes them as racy, I believe, and the officer indicates that they are consistent with, I believe, Playboy magazines. But again, the guidance here is given particularly by statute with the definition of exploitive exhibition, which is a term of art. And so for it to be contraband and for it to be illegal, there has to be an actual showing of the genitalia, the pubic area or rectal area. And as I look in the record, I'm not seeing that part of the body is actually exposed.
Is it your position that the officer's not allowed to utilize his own experience and training and place those images as you've described them in context of that knowledge and experience?
He certainly is. I would certainly agree that he is allowed to use all of his training, and for instance, the comparison to the LS series. So in that situation, this is a hot button issue, meaning this is contraband that the officer says he's seen many times to support charging cases. And so what he did was he asked the witnesses specifically about the hallmarks of those series of images. But unfortunately, he struck out on that. He didn't get those hallmarks, but nonetheless, he continued forward and drew a false comparison to those interviews, even though they didn't bear the hallmarks. They weren't nude. They didn't progress into any sexual conduct. They didn't bear the markers of LS models or the LS series writing on the bottom of the images. But instead, nonetheless, he described them as wearing little or no clothing, and continued to draw that comparison. So I would say he's allowed to draw on his experience, but what he's not allowed to do is create a false comparison when something doesn't match up.
There was writing on the bottom of at least some of those images, names, correct?
Yes, it said names like celebrities. I believe Selena came up, but not the LS models, not the hallmarks of what he was specifically referring them to. And so again, I would reiterate that every time the officer drilled down specifically on was genitalia, was a breast exposed, what was exposed, the declarants came back to lingerie or they were clothed. And so what ends up happening is the officer takes Patricia's statement, which he confirms in his interview, wasn't enough to establish probable cause. He didn't have enough there. He then interviews Zayas and takes her statements, but they don't fit.
When we talk about don't fit, if we were to suppose that Patricia viewed a limited number of the images and Zayas viewed a larger number of the images, are they still inconsistent? Because I'm not seeing how they are.
They do describe seeing them at the same time. Now, Zayas said she saw them first and then again with Patricia. But they do describe seeing them at the same time. So it is confusing that they would be describing totally different age ranges.
Is there somewhere that it says that they saw all of the images at the same time? Because I think clearly what it indicates from the record, from my reading, is that Zayas saw many more and that Patricia wasn't paying an incredible amount of attention. She says she scrolled through them very quickly. So when we look at the difference in attention, is there anything in this record that says they both viewed the same images, all of them, for the same amount of time?
There is in IR 41, which would be Zayas's interview, page 20, lines 20 through 21, Zayas indicates, quote, "I showed her everything."
Okay, I showed her everything. But when you look at Patricia's statements, what we have is she was scrolling through very fast. I'm not sure what I saw. It was a lot of equivocation, was it not?
She was simultaneously able to describe some of the images with more specificity, but did also indicate, as Your Honor said, that she did have some of those indications. But I would certainly argue that I think there's enough in the record to say that they did see the same pictures. Now, obviously two people can see the exact same thing and not notice every single detail. But the way I resolve that is neither of them said that there was any actual exhibition of the genitalia, the pubic area, or the rectal area, which is required to have probable cause for this violation. And again, the officer did continue to ask about that and drilled down on that. And every time he did, he was met with, they were clothed, they were wearing lingerie. He never got an affirmative yes when he tried to go into those specific points. And as Judge Winthrop pointed out, this is an officer who does have expertise in this area, can rely on his expertise. And as he's doing this interview, he's specifically trying to draw that out, and he's not getting it. The reason he's not getting it is because it's not there. And so continuing on, so what the officer ended up doing was he cherry-picked certain statements out of these interviews, omitted the discrepancies, he misled the magistrate, and still at that point doesn't have enough for probable cause, so then proceeds with the LS model false comparison. And my argument for your honors is that this is not a fair presentation to the neutral magistrate. The standard is probable cause, and what we have is a system where the neutral magistrate is looking at what's put in front of him or her, period. There's no cross-examination, it's not a trial, and so this probable cause standard is the burden, it is the check in place to stop the government from coming into your home. And we simply ask that the information provided be accurate, be fair, and not be misleading, that it be the facts, not an advocacy piece. And I see that I'm at about 8 minutes, so if I may, I'd like to shift gears into the 404B. And I will try to reserve maybe a couple minutes. So here, the standard of review is for abuse of discretion on the 404B issue. And to start, I would certainly argue that we have an element of clear error in this case when the trial judge, Pineda, held that the images were put on the other devices, the thumb drives, the various storage devices, while connected to the Sony laptop. When you look at the record, there's connection records, but there's no matching of those images going to or from the computer and those various devices. So first and foremost, I would say that's clear error. It's in her opinion, and that is simply not supported by the record.
I think that some of the thumb drives were connected to the Sony laptop. Is that correct?
That's correct. That's
but we don't know which ones.
We don't know which ones, and then we don't know if those images were actually transferred. So she indicated in her decision that those images, that there was some transfer between the thumb drives and the Sony laptop. The most that they could say is some of them were connected.
So when we look at the 404 hearing,
Yes.
that wasn't explored by your side of the aisle, was it?
The connection records, or
Correct. I mean, you had an expert testify at trial, I guess.
at trial.
Right, but this was never really explored below.
At the pretrial hearing, where the burden is on the state to show by clear and convincing evidence, in that one, I would simply argue that the level of exploration by defense counsel, regardless of that, the state failed to actually link that up, and it's the state's burden under the clear and convincing standard. And so first I'd start with the clear error, and then I would move into, so again, it all goes back to the two declarants, Patricia and Zayas, and the court relies on their hearsay statements. And you've seen that I've argued that these are unreliable hearsay statements.
Who's to make that judgment? I mean, Because our current case law says that a hearing for 404B evidence is not even necessarily required, that you can actually rely on police reports and statements from victims. How are those cases different from what we've got here? You're calling these witnesses unreliable based on what?
So, based on the numerous discrepancies in their testimony, and then also...
Well, it's not testimony.
Well, I'm sorry, based on the hearsay, you're correct, I misspoke. Thank you, Your Honor.
Their statements.
Yes, based on their statements,
Okay.
based on their statements. But more importantly, the fact that they invoked their Fifth Amendment right to counsel and voluntarily absented themselves from the proceeding. So we're really left with a situation where, so the hearsay declarants aren't available, but their statements lay the foundation for evidence that gets into trial where the declarants cannot be cross-examined. So the primary thrust of my argument there is that creates an unfair situation. It does violate the Confrontation Clause, where there is no there's no opportunity for Carrillo to cross-examine regarding those statements.
When we talk about the Confrontation Clause and we talk about that in the context of a motion to suppress, or in this case, a non-trial setting, and we talk about the rules of evidence not applying, and then we talk about the Confrontation Clause in the context of a trial, does it even apply in the underlying hearing?
I think that's a good question, but I think what we have to do is we have to look at the whole picture of how this was done. So we have evidence in the form of hearsay statements coming in to lay the foundation for this connection between Carrillo and these thumb drives, the 404B evidence. And so that then comes into trial, and Carrillo has no opportunity at trial to cross-examine the very witnesses who laid the foundation for the evidence that supports that connection. And so he is being denied the right to confront the witnesses. It creates a very unfair situation. And I would point out that I'm not asking Your Honors for a wide sweeping holding. My request is very narrow. And it's in situations where you have hearsay declarants that have invoked their Fifth Amendment rights against self-incrimination, which I don't think we have to be very creative to say that absolutely affects credibility, that it's appropriate to say the judge can give no more than de minimis weight to those statements.
If we take it out of this context and put it into the context of, say, a drive-by shooting, where there are 4 people in the car, somebody's killed, officer takes statements, all invoke, are we going to not allow those statements to come in even though each of the 4 will invoke at some later point in time? I mean, they are statements against each individual's interest, and this too is a statement against both Patricia and her daughter's interest in that. Knowingly possessing 5 months, they all knew it was on the computer, they knew what it was, and if, for the purposes of this argument, we assumed that child pornography was in fact there and everybody saw it, invoking their Fifth Amendment right was completely appropriate. So do we just throw out everything they've said, even though they've inculpated themselves in this crime?
No, I don't think we do in all situations, no. First, I would say I'm not certain that they inculpated themselves in this crime, because when Patricia took the thumb drives for some several month period, she indicated that she didn't look at them, she didn't know what was on them. She took them. And then
She was in constructive possession of the Sony laptop as well as the compact laptop by virtue of being in the house.
For it being in her home.
And then her daughter, same thing, knew they were there. And then we get to the fact that the daughter admits that she computer tampered, which is also a crime. So we
Correct.
get that all, those are all statements against their interest. Doesn't that give it more veracity?
Oh, I would argue that that actually tends to show a lack of credibility for their continued egregious conduct. But I would say no, that I'm not saying that in every situation we should throw these statements out. What I'm saying is you need some other indicia of reliability, and I believe based on the totality of what's there, we don't have their stories jibing, and then given their invocation, they're left with, quite simply, scant, if any, reliability. And I do see that I'm out of time.
Thank you, counsel.
Thank you.
May it please the Court, Assistant Attorney General Robert Walsh appearing on behalf of the state. I'm going to talk very quickly about the Confrontation Clause argument, the hearsay argument we just heard, and then I'm going to go talk about the search warrant. First and foremost, with the Confrontation Clause argument and this unreliable hearsay argument, take a look at the record and see that defense counsel made the statements that were recorded by Detective Angel of the interviews of the two Patricias. He wanted to use those particular statements during that hearing to show there was no clear and convincing evidence because they had motives or opportunities to plant child pornography and falsely incriminate him. That was the whole thrust. If you take a look at page 7 of the first transcript of this evidentiary hearing, Judge Schell talks about how he would like to have the statements of these witnesses come in. He didn't think they were going to testify, and he was going to cross-examine the officers about that. And he actually had marked as exhibits, I believe, the discs of the actual interviews. And when you read the hearing, you could see that both of the officers who testify are cross-examined extensively. One of the things, the reason why that's important is that there is State versus Burton and State versus Sutton are both Arizona Supreme Court cases that recognize what federal courts have recognized time and time again, which is that if the defense attorney uses evidence that he later objects to on appeal, if he tries to use that for his benefit at trial, the court will say, sorry, you've invited that error. And this was obviously the linchpin of his case. So he actually was the one relying upon that very evidence he now contends violates the Confrontation Clause. Now, Judge Campbell, you asked some questions regarding the Confrontation Clause. It's only a trial right. We take a look at the precedent from the U.S. Supreme Court and the Confrontation Clause, they've never extended it beyond the trial. It doesn't matter if it comes in during suppression hearings or competency hearings, as in Kentucky versus Stinson, McCrae, and also Matlock or Supreme Court cases that indicate that this is a trial right. In every court, I've cited to you 3 cases. One was a federal case, United States versus Mitchell-Hunter, which collects other federal cases saying the Confrontation Clause does not apply during pre- and post-trial hearings. And I cited 2 state cases that collect authorities from several states. In contrast, the appellant has argued nothing. There's no case to support his proposition. Now, Judge Brown, you are asking about reliability of these witnesses, and essentially defense counsel is saying because they told different stories, because they had opportunity perhaps to download child pornography and say it was the defendants, and they invoked their Fifth Amendment privilege, they're unreliable. Well, the invocation, by the way, has never been something that actually was validated by any sort of judge. They never had a hearing on whether or not these 2 witnesses were validly invoking their Fifth Amendment privilege, because the state was not going to call those witnesses, and it mooted the question. So the fact is they intended to invoke the Fifth Amendment privilege, and as you pointed out, it could be for tampering, accessing the defendant's email accounts in the Phoenix Police Department, also for changing the defendant's Facebook and email accounts as a joke. That's what Patty Zayas talked about. But putting that aside, we know that the Arizona Supreme Court, in cases like State versus Whitney, Jeffers, and this court in State versus Alvarez, said that when you have a declarant who has credibility problems and you could impugn their credibility, that goes to the weight and not the admissibility. So what do we have here that indicates that these witnesses can, in fact, be reliable, assuming, I'm not conceding the point I've argued in my brief that this requirement of reliability is not something we need to worry about under Rule 104. But what indicia of reliability do we have? Well, Carrillo says, I had this computer until May 2010. I gave it to the defendant. And he kept other people, didn't want anyone else to use it. So does Patty Zayas. What else do we have? We have the fact that Patty Zayas says, hey, guess what I found? I found images of these girls in lingerie. And they had these names under here. The mother says what? Look at page 2 of her interview. She says there are actresses like Hilary Duff and Miley Cyrus. And what you do have is you have also Patricia Zaya saying she saw an image with Selena Gomez as the inscription at the bottom of some of these pictures with girls in lingerie. But what do we have? We have Detective Haddad finding Selena Gomez as a search term on the Sony laptop. And we have USB 4 having a Selena Gomez bikini picture that had also been downloaded. We have the fact that the defendant's actually looking on the Sony at child pornography minutes before the police come in. And guess what he's using? His Facebook account, his email, and everything else. There's plenty of information here when you look at it. There's child pornography on the defendant's computer from 2002 to 2004, the compact that he used for police work. Child pornography shows up 2002 to 2004. Did Patricia Zayas and did Patricia Carrillo sit on this information for how many years and now all of a sudden spring it? Are we also forgetting the fact, I mean, this is what makes the defense challenges to the credibility of these two witnesses ridiculous. It's in March of 2014 they see these images. Do they call the police? No. How does it come to the attention of law enforcement? Patty Carrillo tells her doctor, and she doesn't know her doctor's going to then tell the police, and the police are going to come talking. So there's sufficient reliability. Now, when we look at the evidence here with the clear and convincing evidence, defense counsel takes a very item-by-item approach. And that's not what we're supposed to do. In Huddleston versus United States, the U.S. Supreme Court indicated the pieces of evidence by themselves may not be enough to establish a point. But in accumulation with other evidence, it can. There's that old expression that we use in our evidentiary rulings that basically the sum of a presentation can be very well greater than the sum of its parts. And when you take a look at everything together, we have what? We have child pornography on the compact computer. It has the defendant's Phoenix Police Department documents up to 2002. Child pornography shows up on that 2002 to 2004. Is Patty Zayas the reason why? Well, she was 15 when she moved in with the defendant in 1998. So let's do the math and say from 18 to 21, is this woman downloading child pornography on the defendant's computer, not telling anyone? Is the wife doing the same? What about the thumb drives? 2008 to 2012. And one of those thumb drives, as I've already indicated, had Selena Gomez's picture, and that was, of course, on the Sony, and it was something that Patricia Zayas saw.
Counsel, I want you to, I know you've got limited time, so I want you to really address, once Judge Foster granted the Rule 20 motion, how did that affect the pretrial ruling on the other acts evidence?
It didn't, and it potentially could have, because the prosecutor dutifully observed, Judge, wait a second, this PNY thumb drive that you just granted a directed verdict on, well, I have other thumb drives here. Are you undoing Judge Panetta's ruling? And initially he was inclined to do so, but defense counsel didn't want, he was actually saying, no, it's okay if the state mentions these thumb drives. Basically, we also have a couple of other things that happened too. At the trial, the defendant testified. He presented evidence. The state didn't have that problem when they had the 404B hearing. And the state was allowed to offer the hearsay statements of the two witnesses who weren't there during trial. And as I pointed out in my brief, there was some confusion by the prosecutor. She believed that the thumb drives were in the same bag as the Sony. At trial, the defendant said, that's not my computer. It actually was in the compact bag. And so the thing is, the facts changed, essentially, by the time trial came. But the defense attorney was given an opportunity to basically strike that evidence. The court even said he was thinking about it. But he said, oh, he wanted to use that evidence too. So there it is. It's here.
If it was error, it was invited, is what you're saying.
Right. Now, one thing I think would be very important here, in my brief, I talk about the evidence that we have regarding all three of the species of digital media, the Sony, the compact, and the thumb drives. I want to talk very quickly about harmless error because I attached to my brief exhibit number 27, which was Detective Haddad's report, and the prosecutor talks about this during her closing argument. The defendant's story at trial is this. Home alone, my wife leaves, I'm doing housework. I feel like looking at the internet. Let me take the one computer in the house that doesn't belong to me and put it on. I know it's notoriously slow, so I'm just going to walk away from it. He says the computer was on for an hour. He comes back, it's a black screen. He thinks it's in sleep mode. Hits the button, the screen comes up, there's his CoxNet page. He clicks onto a story, and then what does he see? 2 credit card boxes. Says this computer's screwed up, puts it away, and then the police knock on the door. But what does that report that Detective Haddad show? It shows from the very beginning that thing is the number one in private mode. Number two, it shows it was only there from 4:59 p.m. to 5:35 p.m., not an hour. And if you take a look at that document, you'll see that he has multiple browsers open. He's actually looking at Facebook when the charged images are being downloaded at 5:10 p.m. At the very beginning of that viewing session, when he looks at, I think it's called Sweet Mods, which is a child pornographic site, he's on his Cox email account. He's on Twitter. You see Adult Police Web, but he's a police officer being mentioned. You know, you have Ashley Madison. How do we know that's reliable? His wife believed that he was having an affair. I mean, you take a look at this, you don't have that type of issue. And I want the court to take a look at that exhibit, and you'll see that this virus theory, that the computer went rogue, even Lonnie Dworkin had to acknowledge there are no viruses that are known to download child pornography. That it is possible for, like, you go to CNN and you have all those different stories and advertisements. When you go to CNN, it'll download all the URLs of those embedded documents. There were no active viruses found by Lonnie Dworkin. He said that he found 152 potential viruses, but he never checked to see whether or not they were actual viruses. Detective Haddad said that he saw 7 potential viruses, but none of them had been activated. So when it comes down to it, you could resolve this issue on harmless error. Now, before I move on to the next topic, may I ask the court if you have any questions for me on this issue?
Okay. Just turn back to Mr. Thompson's comment about clear error, that there was no at the evidentiary hearing going back and in front of Judge Panetta, there was no matching of the devices. It was inaccurate. But what Judge Panetta found, how does that affect her ruling?
Well, the thing is, Judge Panetta took a global approach. She looked at all the evidence and said there's child pornography on these 3 things here. The defendant has his name. He accessed SRP. He used his email account on the Sony to pay the SRP bill. That particular finding, basically, Judge Campbell, I think you are on to what I'm about to say. I mean, the defendant owned that computer from May of 2010, and there was child pornography found as early as November 18, 2011. It was a cookie for, I can't remember the website, but it's like preteen or something. And essentially what you do is you have the child pornography being found on the thumb drives between 2008 and 2012. Well, you basically have about an 8-month period where there's an overlap between the child pornography found on the Sony and on the thumb drives. I think that Judge Panetta made a mistake. I don't think that part of the ruling, you didn't see me defend it in my briefs. I'm not going to defend something I think is factually wrong, but her ruling is sound. And again, you have the right result, wrong reason doctrine that you can invoke here. But that's my answer to your question. I think it was just a mistake on her part. Okay. Now I want to turn to the Fourth Amendment issue. I have to be very careful here because when I was listening to Mr. Thompson, he was talking about the search warrant, whether or not there's probable cause, and then he would lead into conversations about essentially a Franks issue. You're stuck with the 4 corners when you're determining the validity of a search warrant. And then when you deal with Franks, you're talking about what information could have been put there or whether or not it shows anything in the affidavit is false. So what I want to do first is talk about the facial validity of the search warrant because this is where Mr. Thompson began. What do we have? We have 3 people who come forward, a doctor, and the doctor leads the officers to these 2 women. They're not confidential informants, they're not anonymous, they're making a face-to-face tip. Now, the defense says, well, Patricia Carrillo's information wasn't enough to establish probable cause, so it has to rest on Patty Zayas. I disagree. Even though Patty Carrillo may not have provided sufficient probable cause of her own, she did in fact say at the beginning of her interview, look at page 2, and it's in the affidavit as well, this is what Judge Sanders validated, that her daughter had seen images of girls 12 to 4 with little or no clothing. We also have the fact that Patricia Carrillo, after she discovers this child pornography, she's shown it by her daughter. What does she do? She goes and she gets thumb drives. And she takes only 4 of them, and she looks at them and she keeps them, and she wonders if they have child pornography on it, and she gives it to the police. So you have that type of information. You have Detective Angel's opinion that these images are consistent with LS models. But when we take a look at what really is the heart of the probable cause, those 2 things I just mentioned only bolster what Patty Zayas said. Now we have images of girls 2 to 3 years old in lingerie, posing like they were in Playboy, some adult magazine. And the focus of those images are on their genitalia. Now, defense counsel in his brief focused solely on genitalia. Now, when I read that interview by Patty Zayas several times, and the officer's asking, do you see genitalia? And she's like, well, the legs were spread. He's focused on that area. Well, can't you have and there's no statement one way or the other that they're nude, you can see the vagina, or you can't. But wouldn't you think when you have 50 to 100 pictures, that at least one of them, if you're wearing lingerie, might show a vagina? But it's just, the judge can make a common sense deduction, so can the officer. But let's assume for the sake of argument that you don't see a vagina in any of those pictures. But you see, if they're looking at it, zooming at the genital area, aren't you going to be looking at the pubic area? That's part of the definition of a sexual exploitation. That's a part of the statute they ignore. And you can, in fact, have a person be liable for child pornography by showing these types of pictures. I cited to you federal cases that say that it doesn't violate the First Amendment to have such a construction, and you have to give meaning to every part of the statutory definition. That's what State versus Garnica and State versus Cassius say, and they're reading out of it.
So, counsel, you don't believe the statute requires the models to be unclothed?
Right. That's right. And in fact, when you take a look, what we have here is pubic or rectal areas. So the other thing, too, is I cited case law from the U.S. Supreme Court in here that basically says that when we're taking a look at probable cause, we don't have to have an actual showing. We don't have to have a prima facie case. We just have to have a fair probability. And I cited to the court cases where all the officers were given as information was, I found kids nude. And the defendants in all the cases I cited said, but there's no lewd or lascivious type of exhibition here. In Lapson's, it was a case as to whether or not the images were actually real children as opposed to virtual children. But the court said you don't have to worry about that. And there are many cases, I didn't cite all of them, that reject the notion that in order to have probable cause, you actually have to have a witness say, I saw child pornography. It fits the statutory definition. It's not necessary. But anyway.
Is that where the officer's experience and training plays a role?
That certainly helps. That certainly helps, yes. Because I want to also point out something before I forget. The officer only talked about that LS model series because Patricia Zayas interrupted the conversation. So wait a minute, I saw names at the bottom of these pictures. And that's what got the officer interested. Names of Selena and actresses. And that's what started him rolling on his questions. So I wanted to talk about that. There are a couple of things I want to point out before my 3.5 minutes are over. On the staleness issue, there's the argument that the detective didn't put anything explicit regarding the fact that deleted images can be found on a computer even after they've been deleted. And I've cited cases that say that it's common knowledge, even Patty Zayas knew, that you could still find these deleted images on the computer after they've been deleted. Page 6 of the search warrant affidavit, I'd like the court to take a look at the first 2 paragraphs. The magistrate is asked, can you please give our investigators permission to make a duplicate original? And why do they want to do it? They're going to look at deleted and erased files. So it's there. I do want to inform the court, too, that it appears in the opening brief, or the answer to the reply brief, there was this notion that Patricia Carrillo was out of town for 5 months. The idea is that she saw the child pornography in March and left for her mother who was hurt or dying, and then she came back and couldn't find the child pornography. Please take a look at pages 26, 28 through 30 of Patricia Carrillo's interview, and you'll see that she was actually only gone for 2 periods, one from April 10th to 21st and one from July 31st to August 14th. So that point I needed to make.
Why, counsel?
What's that?
Why is that relevant? Why does that make any difference, in
What?
your opinion?
Well, they include it in their affidavit. They wrote a redrafted affidavit. And as far as I'm concerned, even if that did happen, we could still recover those deleted images. It really doesn't matter. So you're right. But there are a couple of things I wanted to point out about the redrafted affidavit. They don't mention the lingerie in the poses being like an adult pornographic magazine. They don't mention Dr. Collier's report as to what Patricia Carrillo told him. They don't mention the fact that Patricia Carrillo, after seeing this child pornography or these images from her daughter, wound up going and taking the thumb drives. That's missing. They don't mention the fact that Detective Angel, during his interview, said that the LS models, that inscription doesn't appear on all the LS model series. Take a look at pages 10 and 11 of ROA 39. He actually says that on the originals, yes, that will be there, but as these pictures get traded, uploaded, downloaded, that usually gets cropped out, or it often gets cropped out. You asked a question about the images that Patricia Carrillo saw versus Patricia Zayas. Were they the same? Actually, when you look at Patricia Carrillo's interview, what does she do? She says, I didn't see all of them. She saw a certain number of them. And she indicates that, they were going by pretty quickly. Patricia Zayas actually found those images, so she would actually have more opportunity to see them. Now, I want to ask, since I have a minute, does the court have any questions for me so I can answer any concerns you may have? If that's the case, I ask the court to affirm the trial court's rulings. The search warrant was, in fact, valid. There are no Franks violations that were material. I've briefed it extensively. I've given you everything I have. On the other act evidence, if you want to avoid the whole thing, you could easily find it harmless. But there was no error, no violation of the Confrontation Clause. There was clear and convincing evidence. You look at the totality of the circumstances. Who else could it have been but the defendant? Who else could it have been? It's like the doctrine of chances. You have an innocent explanation, but when you have repetition, that innocent explanation gets less and less and less likely. These women didn't want to come forward. They didn't want to tell their story. Actually, Patty Carrillo had a financial interest in not incriminating the defendant. She was hoping to live off of his largesse until she graduated from school. You don't kill the goose that lays the golden eggs before you get the last one. Thank you very much.
Thank you, counsel. We thank you both for your arguments here today, your fine briefing. We will take this matter under advisement, issue a written ruling in due course. We will take a brief recess to get the courtroom set for our next arguments.